Welcome, everybody, to the Orange County Bar Association Labor and Employment Law section. Today, we're doing the key case updates on the case published during February of 2025. I am Javier Rivera Carbone, here to introduce our speakers. We have Hannah Green from the law firm of Dorsey and Whitney, LLP, and she concentrates her practice in representing employers in California. Benjamin McLean is with the law firm of Elking Gamboa, LLP, representing plaintiffs in employment law matters in the state of California. Hannah and Benjamin, take it away.
So the first case that we're going to be talking about today is going to be Rodriguez versus Packer Sanitation Services. This case involves Jose Rodriguez bringing a complaint as a representative complaint only. This meant that in the PAGA action, he did not seek to represent any individual PAGA claims, but solely sought to represent others in connection with this case. At issue was whether or not he could do so in light of the recent June 19, 2024 amendment to PAGA, which incorporated, amongst other aspects, that a plaintiff must individually and personally experience the violation before that plaintiff is able to represent others in a representative capacity. This plaintiff had signed his arbitration agreement back during the days before this amendment had ever taken effect, and when Espanian was still at issue. So the issue was whether he could actually represent others in a representative capacity, even if he wasn't seeking to represent his own individual claims. The court considered this issue and addressed it from a procedural aspect. Defendants contend that because there's a standing component now, this necessarily implicates that an individual PAGA claim is also at issue in order to be able to represent others in a representative capacity. But the court looked closely at the procedural aspects and found that because there was no actual individual claim that was asserted, it was not necessarily going to be proper to file a motion to compel arbitration. Essentially, in other words, what this meant is that a PAGA claim should necessarily include an individual claim in order to represent others, but that doesn't necessarily mean that it does here in this case. However, in light of this developing case law, where we're now trying to reconcile the current amendments to PAGA with existing authority, it still leaves open the issue as to whether or not a demur or motion to dismiss would be proper, where the plaintiff must first establish the standing prerequisite that they personally and individually experienced the violation, and they signed an arbitration agreement that would compel their individual PAGA claim to arbitration before that plaintiff is able to necessarily represent others in connection with a PAGA action. So what I anticipate that we're going to be seeing is a lot more of these PAGA actions that would generally have proceeded straight to court are first going to have an arbitration component to determine whether or not this plaintiff can actually, in fact, represent others.
Yeah, Hannah, thank you. I think the court got it right on the procedural issue. You can't compel a claim that doesn't exist to arbitration. They should have filed a demur, and the Court of Appeals is a court of limited review. They can't decide that demur should have been sustained when there was no demur. So I think court got it right here. But I don't know. I think Headless is still basically dead. Leaper all but killed it. And I don't know that this resurrected it in any way necessarily, because it was just decided on this procedural issue. And I don't know why plaintiffs' attorneys would waste time trying to squeak something past a defendant, hoping they don't demur. You're just inviting extra litigation. So the result is arbitrating your individual claims, like you said, which, although it's just an extra step to make plaintiffs jump through and is not that big a deal, it's still 6 months to a year for something that isn't really the point of what you're trying to do. Making us arbitrate these claims, these individual claims, is kind of just a way to waste our time. There are other things that can result from that. Another case may beat you to the punch while you're stuck in arbitration, or some plaintiffs may get worn out from waiting, I suppose. So yeah, look, arbitrating individual claims does have a deterrent effect, because you can get bogged down working on the individual claims, and sometimes the other claims never make it back to court. So this is a pro-employer case here. Let's move on to the next case. This is going to be Moniz Viadeco, USA. And here we have two different PAGA reps with overlapping suits battling it out. Moniz and Correa are the two reps. Moniz settles first. Correa challenges the fairness of the settlement. Court said, that's fine, you can challenge, you got standing. So Moniz, the original settler, revised the settlement, and the trial court again approved the settlement over Correa's objections, and then Correa appealed. And while the appeal was pending, the California Supreme Court decided Torrieta, as we know, which found there was no authority to intervene in overlapping suits, and a plaintiff in an overlapping PAGA suit does not have authority to move to vacate a settlement judgment and then appeal that denial, because basically the PAGA statute was silent on everything. So we can't write in words to the PAGA statute, so can't intervene. And that basically means Moniz is done, right? Wrong. Torrieta included a little tag on that it was not deciding whether a PAGA plaintiff could have a personal interest in an overlapping suit that might support the interest requirement for intervention under the Code of Civil Procedure, Section 387, which we know applies to class actions where people can intervene all the time. And so this offhand comment in Torrieta basically formed the basis for Correa's new arguments. And he tried to ride the Torrieta personal interest caveat, saying, hey, I got a personal interest because I worked there and I was aggrieved and I stand to get money here. But the court wasn't buying it. Court basically said that the personal interests Correa asserted are kind of just tied to her PAGA action and arose by virtue of PAGA itself and are mostly derivative of her PAGA representation for the state. So in light of Torrieta, Correa didn't have standing to challenge the fairness of the settlement. So can't challenge, can't intervene, can't try and overturn these big settlements. And practically speaking, that has consequences. Even though you can get the LWDA involved, you can still kind of suggest to the court that you think something is unfair. Those are your tools now. This case is problematic because there is no real mechanism in place to make sure that settlements are fair, other than the overworked LWDA. So there's now a big incentive for defendants to reverse auction, a practice where defendant basically can sell the case to the lowest bidder. And in the class action world, when that happens, you move to consolidate, you move to intervene, you step in and tell the court you think the settlement is unreasonable or unfair. You need to reevaluate, here's why, and now you can't do that. So this incentivizes plaintiffs' attorneys to rush to settlement. And therefore, there will be lower PAGA settlements because everyone is incentivized to race to the bottom. There's no question that the tool of valid threat of intervention would have resulted in plaintiffs' attorneys coordinating more to get bigger settlements. So because of that, this is a big win for defendants and not for plaintiffs' attorneys.
When it comes to this case, I think at the point where you have a PAGA and class settlement, as the two are often combined, there's generally been mediation. The parties have all come to the table, and ultimately, it's all parties' interest to get these actions resolved, and to really frustrate the process of being able to effectuate and give full force and effect to these settlement agreements that have been, meticulously considered by all parties. It really presents an administrative hurdle, and also, it prevents people from getting paid. It prevents the actions from getting resolved and being able to move forward. So, essentially, this is a situation with the point with settlement where often parties don't necessarily disagree, whether you're on the plaintiff side or the defense side. It's about trying to get these actions addressed and moved through court, because we require the court's involvement to get these actions and the settlements approved. And so really what it comes down to is where you would have individual plaintiffs being able to essentially frustrate the ability of another settlement. it creates this tension that could ultimately dismantle any settlements from being able to move forward in practice. So really what I see here is now just it's a mechanism of addressing the administrative components on how do we actually handle these types of settlement cases where you have so many different plaintiffs counsel representing different individuals, and also when you have very large companies. So there could be a number of different people at different points in time who are seeking to resolve, various claims vis-a-vis the PAGA and class action settlements.
Yeah, I appreciate my colleague Hannah Green's contention that intervention will frustrate the settlement process. We all appreciate efficiency. I think the main point for us here on the plaintiff side is it's gonna result in lower settlements across the board. And that's an issue, and it's a bummer. But we can move on to the next case, and the next case is Casey versus Superior Court. This just deserves honorable mention. This case involves the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. The court said that this federal law precluding arbitration in sexual harassment cases preempts state law attempts to compel arbitration in sexual harassment cases. Can't compel a sexual harassment case to arbitration. And additionally, a choice of law provision does not override the federal statute's applicability. And importantly, where a plaintiff's case includes a sexual harassment claim, just one federal law renders the entire case non-arbitrable, which is huge. Win for plaintiffs here. And I think plaintiffs will add on the fence sexual harassment claims to their complaints because of this, which creates a bit of inefficiency, but is what it is.
The last case that we'll be addressing briefly is going to be Azarte versus AC America Insurance Company. And this case addressed another contention about arbitration agreements, particularly given that this has been so prevalent in many practices. It's not surprising that we see yet another issue when it relates to arbitration. Here, there was a motion to compel arbitration as the plaintiff at issue had signed an arbitration agreement. Now, the contention was where the plaintiff contests the motion, and the court then orders the case to arbitration, who must submit the case itself actually to arbitration? Is it defendant or is it plaintiff? The court looked at the agreement, and where the terms of the agreement are that plaintiff is responsible for submitting that claim to arbitration, the court came down on the fact that, yes, in fact, even though plaintiff may have contested the motion to compel arbitration, they challenged it, opposed it, certainly didn't want it to prevail, at the end of the day, the arbitration agreement is still such that the terms are that plaintiff is to submit the claims to arbitration.
Yeah. Yeah. And wait a minute, the defendant is the one who wants to go to arbitration, right? What are we doing here? Yeah, this is a good reminder to do that thing that we all sometimes neglect to do, which is read the contract and do what the contract says and scour the terms. But yeah, a bit counterintuitive and could catch some plaintiff lawyers off guard in the future. Thanks, Hannah.
Well, thank you, Hannah. Thank you, Benjamin, for your insights. Everybody watching this video, thank you for your participation. We invite that you attend our next in-person meeting by signing up at the Orange County Bar Association's website, ocbar.com. Thank you, and see you soon.